Okay, so another form of alternate dispute resolution would be mediation. I've been through mediation many times. It does have its advantages. I think I've only been to one mediation where I wasn't successful in settling the matter. But a third party assists the parties in resolving their disputes, and this is obviously done to avoid litigation. That person is called a mediator. The parties agree to use. Now, certainly in certain circumstances, the court will order you to mediation, again, in an effort for the party to try to resolve their differences. Reduces the court case law. There's no judicial review of it. It's quiet. It's not admissible in court. There's no record of it. You just go there and you do it, and if you can come to an agreement, that's fine. Now, settlement is going to be mutual choice. And keep in mind, this is arguably a good thing. There are advantages to it, and the biggest advantage is your ability to control the situation, and you can pursue things the way you want them pursued. Generally speaking, what happens is the parties meet, they look at things, and I'll go into this in more detail in a second, but having that ability to talk with the other person and have a third party listen to the situation, and that third party listen to both sides. Generally speaking, that third party can hear where the compromise is. Now, there's no disadvantage, or there are disadvantages. There's no enforcement to it. And selection of the mediator and their qualifications, you just get a mediator. But keep in mind that once you have that settlement agreement, you could incorporate it into a court order and then make it binding. Now, procedure. You'll go into mediation, and I'm sitting with my client, opposing counsel sitting with their client, and there's a mediator at the head of the table. Mediator goes through his spiel so that he makes more money, but no, because he's supposed to. He lays out the laws, tells them the rules, that we're here discussing issues, none of the stuff that's talked about here today is admissible in court, that sort of thing. Generally speaking, the parties will then give an opening statement, not the attorneys. Based on my experience, it's always the parties that talk, and I say, hey, this is where I'm coming from, this is what I want, yada, yada, yada. Other side does it, mediator listens. Then what you can do is you can break and go into what we call caucuses. And in those caucuses, the parties and their attorney talk to the mediator and tell the mediator what they want. Mediator goes to the other side and talks to them. Now keep in mind that you can tell a mediator not to disclose something. Okay, and he has to. And believe it or not, folks, I have never seen a mediator be all sneaky and stuff and evil and try to take advantage of a situation. But what happens is through the process of going back and forth, very similar to negotiation, you're just using a mediator. You can usually get these things resolved. See it a lot in family law. See it a lot in personal injury. And again, this is done in an effort to let the parties resolve their dispute, not the courts. Because again, you never know what's going to happen when you go to court. Now, other alternatives. You can do any type of combination of the above. And believe it or not, especially when you're in mediation, negotiation will be a huge part of it. You can do mock trials, okay? Citizen review, and that also will tell the plaintiff really what's going on. If you hire a few people to come in and sit on a fake jury, go through the odds and ends of the trial, then you have an idea what might happen at court. You have a mini trial. You can focus on central issues, and you can go back to the business problem. What is going to happen if your business goes to trial on this matter? So again, think about this. You have litigation. We've gone over litigation, but to avoid litigation, you can try to work out the problem yourself through negotiation, arbitration, mediation, or some other form. And again, these other alternatives, alternate dispute resolution, has become very popular, and courts favor it. So if you can do it, do it. And again, listen to your attorney when they're trying to tell you where to go in terms of settlement and negotiation. They've been there before. They know what may or may not happen.